Good morning to everybody. A keynote is a funny thing. It has to be at the same time surprising, but must not be confusing. It must be thoughtful, but not too thoughtful and heavy. It at the same time must be structuring the day to come. So it has the task to structure and perhaps as well the task to disrupt. Data protection is a success story. This claim is often heard, although frequently disputed, not only by data protection authorities, which try to bring down Facebook, or by Facebook itself, or by the notorious bakery around the corner, der Bäcker die Ecke. I think that data protection must indeed be a success story because it is a multi-purpose tool, a kind of Leatherman for the information society. The scope of application of data protection and data protection law is so broad that without hesitation it is applied even to big data, so statistical data applications, and thus originally the exact opposite of personal data, which data protection law originally has been designed for. So it is not surprising that data protection and data protection law is expected to address all kinds of problems of the information age, including artificial intelligence. Remarkably, it is hard to pinpoint the exact meaning of data protection. The only thing that everybody might agree on is that data protection is not about the protection of data. Beyond this point, the field and the definitions, the field is open and the definitions vary. The concept of data protection, as we all know, originates from Germany. It has been widely adopted by the EU legislation, but when we Germans say Datenschutz, data protection, we usually mean informational self-determination, informationelle Selbstbestimmung. But this original idea from the 1970s is, as far as I can tell, has had next to no influence on the EU legislation. So the German idea, informationelle Selbstbestimmung, has kind of given birth to data protection on the European level, but on the European level, the underlying concept of informationelle Selbstbestimmung has not been adopted. Funny thing. The situation with the term privacy is even more confusing, and this is because privacy has many meanings and facets. You will notice this if you try to translate privacy into German language. You can choose from Privatheit, Privatsphäre, Privatleben, Vertraulichkeit. So a wide, it has many meanings. Beate Rösler, the very well-known German-Dutch privacy philosopher, she alone has identified three kinds of privacy: decisional privacy, informational privacy, local privacy. Others see privacy and public as complementary concepts, so that privacy cannot be thought of without thinking of public, the exact opposite. In the political discourse, we have an antagonism between privacy and security. And privacy, anyway, is perceived in different ways over the times and understood in multiple ways in different societies and cultures. So, data protection is a broad success story, and its success is based on this term being so broad and not being exact. Because it is so broad, clarification is needed if we want to talk about privacy and data protection, and that's what this conference is about. The clarification of the term privacy and data protection and how these terms and definitions are related to each other is vital for professional communication. And we have two approaches to cope with such a problem. We can either try to find a universal approach, a universal definition of data protection, or we can try to deconstruct the concept. It is most likely not to be successful to try to develop a universal and uniform definition of standards. You are most likely to add just a new one. It is the likewise famous and funny cartoon addressing this problem. I think most IT people have seen this cartoon a million times. So, trying to find a universal definition, a universal concept of data protection will not be successful. Therefore, I prefer to do some deconstructing. I do not see, and I recommend you not to see data protection as a concept itself, but as a cascading combination of concepts and approaches. Therefore, I will now briefly slice the whole concept of data protection into 5 layers corresponding with 5 regulatory approaches. Liability, the regulation of individual submission to data processing, the regulation of collective submission to data processing, regulation of technology, and compensating, regulating on a social level. This will help, or this is intended to help you to structure your discussions throughout the day, because many misunderstandings and lacks of communication originate in that people are talking on different levels at the same time. The first level is the level most used to lawyers, because liability, Verantwortlichkeit, Haftung, is the first thing lawyers think about. This general concept of damage and compensation for damages exists in data protection as well. But so does the general prerequisite for damages, also die Voraussetzung für Schadenersatz, and this prerequisite is of course damage. Schaden. Kein Schadenersatz ohne Schaden. The problem is that in data protection and data protection law, damages are very rare in real life. I can tell you because I've commented on the respective provisions and I've written a textbook chapter about this. There are next to no cases about damages in data protection. So this basic and fundamental legal concept does not work. The explanation for this, why this is a white spot, a regulatory white spot liability, is that it is the task of data protection law not to address damage, not to address a happened damage, but they address hard to translate, they address the Vorfeld, the environment of liability. So the objective of data protection law is that a damage, and so direct liability, is not going to happen. So this concept is basically a white spot. This is the hot spot of data protection, regulating the Vorfeld, the environment of actual damages. A third layer which can be identified, addresses collective submission under data processing. We do not have prominent examples for this collective approach in law, at least not in the free and Western world, except for German labor law. As you all know, German labor law provides for specific regulation protecting workforces as a collective. And if, for example, algorithms are used to define working hours and to monitor performance of employees, the Works Council, Betriebsrat oder Personalvertretung, has the right of co-determination, Mitbestimmung. The GDPR, and formerly the German Data Protection Act, Bundesdatenschutzgesetz, knows a similar institution on a collective level, and this is the data protection officer who is able to enforce or at least to promote group rights. So not only individual rights, but the rights of a collective, and thus is able to focus and tackle structural deficits and imbalances, and is not thwarted by individual phlegma and rational apathy, rationale Apathie of the data subjects. A fourth level is, of course, technical measures and technical regulations. Problem with technical regulations is that technology is changing in a very fast way, and law is not, so law is always behind. The approach of the GDPR to be technologically neutral leads to an anematic and bloodless structure. Fifth layer, regulation on a social level. This level is usually discussed on a political level. It is about solutions of the cohabitation of man and computers, and issues at this level. It is about education, it is about raising awareness, it is about introducing new legal concepts like data property, Dateneigentum, which may help to adopt society and people to new social and technological circumstances. The benefit from this layer model is it's not ivory tower l'art pour l'art, but gives insights into the structure of data protection and privacy. First, it shows that we have a cascading model. Because of the sensitivity, we avoid regulation only addressing liability. I think in the US the approach is different, but in Europe we don't address liability. We have these four other layers to prevent situations that damages and liability even occur. This, as already said, this layer might help you during this conference to position yourself in one of these layers and to identify the positioning of your discussion partner perhaps on another level, and you will then see that, and at least then you are aware that you're talking on different levels, which is a first way to improve understanding. The third upside of this layering model is that it helps to understand tensions and frictions within data protection law. Everybody knows from school how a bimetallic strip works and how the neat application of thermophysics helps us to keep our homes warm and as a constant temperature. In data protection, we have 5 layers. And as far as I can see and remember from my school days, nobody has yet found a sensible use for a trimetallic strip, even less for a 5-fold centimetallic strip. The reason is obvious. Differing dilatations, Ausdehnungen, lead to unpredictable twists, tensions, and frictions. And this is the explanation why discussing data protection and privacy is so difficult. This five-fold cascade offers an explanation for inconsistencies which occur when applying the GDPR or data protection law in general. If the ribbon of data protection is folded 5 times, 5-fold, quintupulate, it forms a bimetallic strip of 5 layers of pentametal. It does not only bend in different temperatures of privacy issues, but shows odd movements, which result in theoretical frictions and practical legal toothache. I wish this conference and all you participants, of course, no toothache at all, but lots and lots of input you can chew on. Tuck in.